Hey, what's up, guys? I don't know if I'm actually live yet. I gotta probably do like an intro thing. I think things will catch up in just a second. I'll wait. I'm waiting for we should be live on YouTube and stuff now. See, I'm using Rumble Studio again, which is good. They finally fixed whatever weird stupid problem I was having. And now I need to like get the YouTube link out there. So give me just a second to get that out there. Hold on. I think we're going to start broadcasting on X as well soon. X? That feels weird still. Feels weird to call it X, Twitter, or whatever. There we go. No. Get rid of that. Get rid of that shit. Yeah. Hold on. We're almost there. We're almost ready. And then I'll like, whoa, shit. I'll say intros and stuff again in a second. Woo! What the? Live right now. Come join me. Please come join my show. Okay, hey, what's up, guys? Welcome to Lost Plating the Interwebs. I am your host, Nick Ricada of Ricada Law, small law firm, small law form. Just one little form that you fill out in central Minnesota. What's up, guys? How you been? How you doing? I was a little late. I wasn't terribly late, but I was a little late. Don't give me credit for that. Don't you do that to me. You don't fucking jinx me. No, I'm the one who does the jinxing here. I'm the only jinxer allowed. We're not going to go with these rogue jinxes running around causing problems with everybody out there. I'm the one who gets jinxed. I am the jinx. Oh my goodness. Still getting my windows set up here. My bad. Hope you guys are doing well. Oh my God. See Goody. He's alive. He wasn't eaten by like Taiwanese hookers or whatever. So, hey, we've got a bit of a show tonight. We've got a bunch of topics. Oh my God. Now would be a great time to insert ads or aids. We've got a little bit of a show. We've got topics ranging tonight from SCOTUS, lots of SCOTUS stuff. That's the Supreme Court of the United States. If you're not aware, we've also got Jack Smith. We've got the Attorney General of Missouri talking about prosecuting Joseph Robinette Biden and Kamala Harris, the ambiguously raced vice president / presidential nominee for the Democrat Party. So we've got a bunch of that going on tonight. Other than that, whatever you guys want to talk about is there. I've got lots of thoughts. There's some stories I've been following, but I'll give you mild personal updates, but I'm not going to spend a ton of time like just blathering on about it because it's not what you want to hear. I mean, you probably do, but not what I'm going to tell you. Like you want bigger updates than what I've got. But the short story is looking to get back into 3 streams a week as soon as possible here. But the good news on that is had a ton of time with the kids lately, and the kids are going to be back very soon, full time. So getting the whole life situation ready to be back into some semblance of fucking normalcy. It's wild having the kids around again in the best way because it's exhausting. But then when they leave, it's so quiet. And it's unsettling how quiet it gets. So that's been one of the biggest adjustments through all of this bullshit is just how quiet the house is when you're not constantly doing something. They're all old enough to be relatively self-sufficient, but they all want help with something or need some like minor assistance somewhere, interaction, right? Very basic human thing. And you get used to doing it for so long, and then that stops. And it's oddly unsatisfying because when you're in it every single day, you're like, God, I'm tired. Guys, can we slow down? But when it stops and it's taken away from you by certain people, then you just don't know how to function in a place of such calm. So that's been nice like I said, in a very strange way, having the kids around a lot and getting to spend actual like significant amounts of time with them rather than these very short visits that we used to have. And getting the house finalized to have them back full time has just been it's been great, but it kind of messes with the show thing because I'll just be honest with you guys. I think about very few things right now. My main focus is kids back in the house, criminal case. What does life look like as this thing progresses? And I can't talk much about those on the show. So it makes it kind of like getting shows prepped and thinking through these other subjects to talk about gets like that has to be a secondary investment. And it really sucks for the show. And I'm sorry about that for you guys, but that's kind of how my brain has to work and prioritize things right now because this coming month, actually we're going to transition like an Olympics opening ceremony into August over the showtime here. And August is a very, very big month. My child custody case will be finished. My criminal case will be lighting up. So it'll be a lot of fun. Yay. But that's been soaking up most of my brain power. And so I haven't done as much streaming as I wanted to, but that should be changing soon. And we'll just keep going. One more minor announcement. I think I said at the beginning, I'm going to probably try to start streaming to X, Twitter, whatever, as well very soon. Rumble Studio allows very easy multi-streaming to multiple platforms. And as long as it keeps functioning the way it does, I'm keen to keep using it in the hopes that, what I want them to do is when I set up a Rumble live stream, I want it to set up a YouTube live stream like StreamYard would. But right now it doesn't set up the YouTube stream until I actually hit go live. And it would just be easier if like when I schedule a stream out that it would, do both. But that's a minor thing. So and it's a minor thing. Dr. Disrespect might want to talk to it, and we don't want that at all. But we're going to have that fixed up, or we're going to hope that they fix that up at some point. But in the meanwhile, I'm still keen on using Rumble Studio. And I'm going to start adding the, the intros and the outros and the fucking little clips and stuff back in to that very soon. So it's been cool. And we'll do that. I don't know. I'll tell Ryan to do it. Like, he's like, can I help? And I'm like, no, Ryan, you can't help me. But now he can. So I've been looking forward to that. All right, let's hit a couple super chats that have come in. Thank you very much for that. And then we will get on with the show. If there's anything you want to talk to me about, feel free to distract me. Big shout out to locals. Hey guys, what's up? You guys can distract me too. You don't have to pay to distract me. You already did, like with your locals membership. So feel free to send me all sorts of bullshit on the locals chat. I'll be in there tonight, and we're just gonna have a fun little time. And then depending on how late the show goes and what goes on after, I was kind of thinking of doing a short locals live stream as well after the show, but it kind of depends on a couple different circumstances. So we'll see how we go from there. All right, guys, let's go. James Carg says, heard you had a run-in with the law recently. They ran in, that's for sure. Hope you weren't doxxed. Oh yeah, not at all. Past few months certainly have been a real shit show for politics. Damn near saw a civil war kick off with Trump's brush with death. Glad to see you're okay, man. Hey, yeah, thank you. Yes, all of the things you hope didn't happen did happen, but life comes at you at the speed limit or whatever. The question is, do you run faster than that? That analogy didn't make any sense. but I'm going to stick with it. I'm going to stick with it like the Special Olympics. Sylvia's daughter says, I'm so glad to see you looking healthy. My best to your wife and children. Hey, thank you very much. Jim tells you, Dr. Disrespect building Epstein's temple in Minecraft. There's a video of this. What is this shit? This page doesn't exist. Jim, you lied to me. It's not real. Your thing didn't work. Oh no. Hold on. I think it's doing I think it's clicking the link wrong. Damn it. Can we try this one more time? Copy link. We'll do it manually. Like a transmission I can't drive. Yes, I want to go to... No, your link doesn't work. It doesn't work. Does not work. So, okay. There we go. Well, thank you, Jim, for your contribution to society. Although the link just did not happen. I don't know if it's been taken down. Anyway. Man, it's always weird to sit back down in this chair and start talking to myself. Because normally I just talk to myself during the day. Check Twitter DMs. Oh, God. This better be funnier than I know it's going to be. Despite admitting to... Oh, wait. I thought this is going to be a video. Let's see what we got here. I think I can share this. Hold on. Start screen share. Well, where are we? Is this it? Oh, baby. Despite admitting to sending inappropriate sexual messages to minors, Dr. Disrespect has now returned to the YouTube platform. To herald his return, the disgraced game streamer has kicked off an all-day marathon of Minecraft. So he's got... What is he building here? New Minecraft build. Set. Okay. I wonder what kind of numbers he pulled on this. Is this real? Like, is it that he didn't really do that, did he? He's not like, well, I was talking to minors a lot, so I'll do Minecraft. I guess. I don't know. Oh, the guys, that one weirds me out. That thing weirds me out entirely. Dr. Disrespect. I don't know. Like, well, look here. I'll tell you guys what. You know I don't fuck around. Yeah, I did talk to them. It's like, whoa. Doc, slow down. Okay. Anyway, enough fun for the night. On to the news. So a bunch has been happening with the Supreme Court in a bunch of different areas. And that's such a vague sentence. You could say it at any time. But I want to talk about something kind of specific to Minnesota because I like talking about guns sometimes. Second Amendment, pretty cool or whatever. And Minnesota's not great at it. This one is, well, this one's actually not the Minnesota or the state Supreme, or this one is not the U.S. Supreme Court. My mistake. The U.S. Supreme Court has different gun news. They're being a bunch of bitches. This gun news comes from the state of Minnesota, the Court of Appeals, and Attorney General Keith Ellison. So we'll do that and then get into the Supreme Court stuff. My apologies for being so rusty. Oh, dear God. I'm rusty enough to give you tetanus in your mouth. So Minnesota Attorney General Keith Ellison seeks to restore state ban on people under 21 carrying guns. So here's what happened. Minnesota said, okay, you can buy a gun at 18 or whatever, but you can't get a carry permit until you're 21, which makes no fucking sense. Like, let's just put this out there. The whole like guns thing, like having an age restriction, according to the Second Amendment, barely makes sense at all. It only makes sense because we've decided that, oh, yeah, of course, 18-year-old, you have to be 18 to own a gun, which I don't know when that became a fucking course. But everybody now is like, well, yeah, you got to be 18 to have a gun. I mean, that's the only sensible age to have a gun. It's like, why? Well, I don't know. You just is. So you're not, I guess, because that's when you can threaten someone with a gun to sign a contract. I'm not sure. But for whatever reason, we've all just accepted this one societally for a while now, that 18's the reason. But it's not according to the Constitution. Second Amendment wasn't like, yeah, when you're 18, though. It doesn't say that. You know, the right of the people to keep, well, children aren't people, maybe, I guess. Is that what they're trying to argue? I'm not sure. But the right of the people to keep and bear arms shall not be infringed doesn't have an age restriction on it. But we've accepted 18 for a while now. But some states have this little gap from 18 to 21 where they're like, nope, got to be longer. It's got to be longer. Some of these people have heard this a lot. It's got to be longer. So they want an extra 3 years tacked onto that to make it 21 years of age to have a handgun, typically, specifically. Like they're like, no, shotguns are fine at 18, right? Like that's okay. Rifles, 18, but a handgun or a rifle with cool carbon shit on it, that's got to be 21. So let's just be very clear. If the rifle looks cool, you got to be 21 to have it. And so they have these little age gaps that are added in there, and no one can figure out why they exist. There's no rational relation to a 21-year-old versus an 18-year-old having a gun. At least we could say 18 is the commonly understood age of majority. It's where we vest a person with adulthood for making their own life decisions and stuff like that everywhere else. So at least you have that kind of rational connection. The only nexus to 21 is drinking. And they typically want to keep that as far away from guns as possible. But hey, I'm not them, but that's the plan here. These things are finally getting challenged under Bruen. And that happened in Minnesota. They're like, well, why do you have to wait till you're 21 to get a carry permit? That doesn't make any fucking sense. In fact, yeah, it makes less sense than anything else you guys have talked about lately. And they won. Actually got it struck down. So July, the July decision, Ellis is challenging a 3-judge appeals court panel cited a 2022 landmark U.S. Supreme Court decision that expanded gun rights. That's, New York Rifle and Pistol Association versus Bruen. So now the Attorney General of Minnesota is asking a federal appeals court on Tuesday to consider restoring a state law bans people ages 18 to 20 from getting permits to carry guns in public. Like just think like how much they hate guns. That they're like, no, these 2 years, we could stop them for 2 more years. You're like, why? What is the difference for like, look, I've met 18-year-olds, I've met 20-year-olds, they're equally retarded. I've met 42-year-olds that are just as retarded. Don't get me wrong. Like there's nothing about that 2 years, like, oh, they grew so much, they just really came into their own then. They're 20 now, It's very Minnesotan. Oh, they're 20 now, don't you know? Now they're making some good decisions, yeah. But what the fuck is going on here? I don't understand why this, and this is a clutch issue for anti-gun people all over. This 21-year requirement for handguns and for carry permits all over the country. They just get so much smarter by the time they're 21. Like, don't we want them to have guns before they start drinking so they get used to it, at least? So they're not, I don't know. In a petition for rehearing with the 8th Circuit Court of Appeals, Ellison asked the full court to review a ruling earlier this month by a 3-judge panel affirming a lower court decision that Minnesota's law is unconstitutional. And we saw this is straight out of the 9th Circuit playbook. 8th Circuit's where Minnesota is. 9th Circuit is California. But California, of course, there's one guy who always gets the fucking gun cases, and he's like super pro gun. And he wins. St. Benitez, right? Justice Benitez, he fucking always rules in favor of the Second Amendment, in favor of gun rights. And then they always, even when they'll get a couple base judges on the appeals panel and those will squeak through, they'll always rehear a gun hearing en banc in the 9th Circuit because the liberals outnumber the conservatives and you don't get the grace of a 3-judge panel winning 2-1. You don't get that, because they're going to rehear it en banc and outvote you. That's what he's going for here in the 8th Circuit as well. But if we go by Bruen's standard, where, first of all, Bruen's got it. I have to back myself up a second. No, I don't want to check this out before I leave or anything. Why? Why would you do this? Oh, go away. There we go. Got to back up a second. The very notion that the Second Amendment requires a permit for the fucking actual text of bearing arms should offend everybody at their deepest core of constitutionality. Permitting speech, while it does happen, should offend everybody. Permitting your right to be free from unlawful search and seizure should offend everybody. Permitting your right to an attorney, or your right to not self-incriminate, or your right to compensation for a takings would bother the fuck out of everybody. But with the Second Amendment, we're like, well, it says keep and bear, but they meant permit to bear arms. Why we tolerate as a populace the permitting requirement for bearing arms, a foundational constitutional right enumerated directly in the text, is beyond me. And how it is sustained under some weird reasonableness test that the Supreme Court has just failed to, properly attack for so long is baffling. How can we allow states to require a permit to bear arms? For that matter, why do we have to have a permit to purchase? But at least we can say that a federal Congress can regulate commerce. At least there's some conflict of power here between the right to keep and bear arms and the ability to purchase them in commerce, right? Because Congress does have the power to regulate commerce under Article 1, Section 8. So they have the authority to say, yeah, we want to control how these are sold. They may not be able to prevent you from buying them, but they could put some sort of restrictions on there. But actually keeping and bearing them, these age requirements and these permitting requirements are direct infringements of your right under the Second Amendment. And it says right there, don't infringe it. And we're just like, yeah, but I mean, do though. I mean, we gotta be reasonable with our rights here. Huh, it's just silly. It's just silly to think that we could have them. Anyway, sorry. I fucking hate the idea of permitting a right. And we just accept it. We're like, well, yeah, I mean, you got to be 18. You got to get a permit. You got to have a law enforcement agent decide that you're able to do this right that you have. Importantly, not that law enforcement and the judicial system can decide that you no longer have a right. We've allowed that for a very long time. Right? People have the ability to give up their rights. Some people have argued that I would have given up my rights to some sort of liberty if I lose in my criminal case, for example. So they would say, no, you made choices that would lead you to this thing. That would be their argument, right? That's the argument for losing like voting rights or losing, again, your Second Amendment rights and stuff, as convicted felons often have that problem in the United States. The argument is that, well, the government didn't take those away. You forfeited those rights by your actions. But this is a prior restraint on the exercise of your rights. This isn't the same thing. And again, why we tolerate these prior restraints is, it's baffling to me. But of course, I guess the other answer is what? Violent uprising. And I'm not going to advocate for that. Most people who say they want that probably don't. But it's frustrating to me because no one fucking cares. But I care, chat. I care here and here. That's right. The Squid says none of these age laws make any sense. Anyway, they should either make 18 the age for everything or raise the age for military service to 21. If you're old enough to die, you're old enough to drink. But have you considered the ramifications of an 18-year-old drinking? I mean, oh my God. I mean, if 18-year-olds started to drink, what would we do? Country would be in shambles. Shambles, I say. Hallucinosis says, as a California resident and St. Benitez supporter, the average European mind can't comprehend how many magazines I bought during Freedom Weeks, nor the thousands of rounds. Cheers to you, my brother. Hats off. Hide them well. Hide them. because someday someone might come and try and take them from you. And they'll be there to help. They always are. The government is always there to help, my friend. Okay, so anyway, back to this thing. God, I'm just... Okay. The lower court sided with the Minnesota Gun Owners Caucus. We're going to put our Gun Owners Caucus right in your fucking mouth, which sued to overturn the law and concluded the Second Amendment guarantees the rights of young adults to bear arms for self-defense. No, it guarantees the rights for everybody. Why is it young adults? Why? I know they can't push for it. I know, like, believe me, I'm not mad at the caucus. You can never be mad at the caucus. Caucus is your friend, but grab onto it tightly. But I'm not mad at them. I'm just mad at the concept. I'm mad at the concept. It's like, well, we can only go for the... they're like the old guy at the gym. Well, we can only go for the young adults. It's like, why do we have to sacrifice liberty? And you do, because if you're like, no, we want Second Amendment rights for everybody, they'd be like, well, that's crazy. Like, why is that the crazy position? Why is that the insane one? Ellison argued the panel failed to consider the impact of a U.S. Supreme Court decision in June to upholding a federal gun control law that is intended to protect victims of domestic violence. Okay, here, let's just be honest. Let's be honest. Here's why Keith Ellison cites the U.S. Supreme Court decision in June, which I'll explain in a minute. He's fucking retarded. No other way around it. No other... I mean... Everybody says that he aren't they the one that said he was fucking his sister? Is that the one? Or was he the woman beater? No, it was Ilhan Omar was the one banging her brother, allegedly. I don't know. That's what they say. And then Keith Ellison was the one who was allegedly the woman beater, I think. That's the one. What does they have in common? I don't know. Anyway. Whew. Am I allowed to talk about the Attorney General? Is like an attorney major going to come yell at me? God, I hate Keith Ellison. I just have to, in my mind, hate Keith Ellison a little bit more. Hold on. God, guy sucks. Anyway, the June decision that the Supreme Court upheld when they finally protected, whatever, was this Supreme Court case where under Bruen, the argument was, well, if you've got a domestic violence restraining order, you can still have your gun, because there's not a history and tradition of restricting people who have domestic violence restraining orders with firearms. But that was too tight of a reading of Thomas's opinion in Bruen. According to the court, they said, whoa. There are historical analogs to restricting access to firearms for specific adjudicated violent conduct. So in this case, that was decided in June, a judge had determined that someone was a danger, specifically a danger due to violence, and that person should not have access to a firearm, that they had at least temporarily forfeit their Second Amendment rights because they had presented themselves as a specific danger. It was decided by a judge in a court where they had an opportunity to respond. This is not just a blanket ban or whatever. This is this. So the Supreme Court says, look, in cases where a judge, or a court, I should say, has adjudicated someone as a violent offender, there's enough history and tradition of restricting access to firearms in those specific circumstances that we can uphold the ban on possession of firearms by a violent offender. What the fuck does that have to do with 18 to 20-year-olds? Keith Ellison's like, haha, see? If you look at this case, it's like, no, that's not what this case says at all. This case does not say that 18 to 20-year-olds are adjudicated violent offenders. I mean, some of them are, but not all of them. And so therefore it doesn't actually have anything to do with the June decision. So but this is, I say he's retarded, but he's retarded and malicious. He's maliciously extra chromosomed. And the entire purpose of this is, it's just his, it's just the campaign against guns. and the campaign against liberty, the campaign against you and me, the campaign against people who just want to be left the fuck alone. And the reason why it's a campaign against people who want to be left the fuck alone is because the best way to be left the fuck alone is that the government is scared to open your door because what might come back at them when they do. Once the government knows that behind every door there are no bullets coming, they'll open every door. Right now, they have to open select doors, and it takes a lot to open a door. But when there are no guns, and this is shown throughout history, throughout governments, throughout systems of government, throughout right wing versus left wing, throughout dictators versus democracies versus whatever communist tyranny you can conjure up in your goddamn social studies class, it's always the same. Once there's no guns pointing back at the government, your doors are open like a butthole in prison, man. They're coming in, whether you let them or not. And that's what this campaign is about. That's why all these states want these little chip away at your rights. They'll chip and chip and chip until the right is useless, meaningless. If they can set an age restriction from 18 to 20, guess what? That age restriction is going to go up to 25. Then it's going to go up to 35. Hawaii tried to raise the smoking age to 100 a while back because they're like, well, if we can regulate smoking at 18 and then at 21, why can't we just raise the smoking age to 100? And some judge was like, whoa, that's ridiculous. But when you think about it, why is it ridiculous? I mean, from their perspective, if you can regulate at any given age over 18, again, 18 somehow has become like the common understanding of the age of majority. But if you can go beyond 18, just say, no, there's another age that is relevant under law for whatever reason. All you have to do is just start establishing that there is another age that's relevant. 21 is only to drink. And the U.S. government did that by coercing all of the states into this with Department of Transportation dollars. If you don't know that story, maybe we'll talk about it sometime. But it's actually a really great case. North Dakota was the last holdout of states that refused to raise the drinking age to 21. And the U.S. government said, fine, no DOT dollars for you, bitch. And oh, there we go. There's a little circle going on the one screen, and it was on my YouTube screen. I thought the stream stopped. Anyway, he said, if you don't raise the drinking age to 21, then you don't get your Department of Transportation dollars, which was something like 5% of the entire budget of North Dakota at the time. It was an insane amount of money. And North Dakota's like, well, okay, I guess we have to do it then. That's why your drinking age is 21. It's not because there's some logical nexus between the age 21 and drinking and driving and all of that stuff. It's just because that's how they did it. That's just how they did it. And you find that with government over and over and over. When you find these little restrictions that seem to be common across several different areas or several different locations or localities, you go, well, why is it this way? It's like, well, because it was. Just look at Roe versus Wade, right? Well, they can have abortion up to the second trimester or whatever. They have to have it. It's like, well, why the second trimester? Well, because that's what these guys in the robes decided. But what is significant about 28 weeks in, it says, well, now you can stop them from killing the baby. Like, it's an arbitrary choice. That one was actually based on the medieval idea of ensoulment and the quickening and all of that stuff. But don't talk about that because it's very science-based. But all of these things come out, and it's just because someone said so. But if we allow these arbitrary and capricious guidelines to exist, then they'll just keep creating them. And that's the fear of anyone on the freedom side of the fucking 18 to 21-year-old argument on guns or carry permits or whatever, is that once you set 21 as this default second age for your second adulting, right? Like 21 is when you're more adult now. And why is it 21? Why not 20? Like, who picked 21? Who even decided that 21? It's like, why not 22? Why not 20? 20 is an even number. 21 doesn't make any fucking sense. Like 3 sevens with your a slot machine? Probably. All right, back to this. Quote, I believe this is Keith Ellison again. I believe the court erred earlier this month in ruling that the Second Amendment requires Minnesota to allow open carry by youth as young as 18. Now, that's cool. Ellison said in a written statement, respectfully, I believe the court reached the wrong conclusion on the facts and the history, especially in light of the Supreme Court's recent common sense decision to uphold a federal law criminalizing gun possession by domestic abusers. See, you can see the logical connection there, right? Like, I mean, why would, of course, a finding that people as young as 18 can open carry has something to do with domestic abusers and criminalizing gun ownership. Obviously, those two are the same thing. Surprised Keith Ellison is okay with no guns for domestic abusers. In the July decision, Ellison is challenging the 3-judge panel, appeals court panel cited 2022 landmark Supreme Court decision, expanded gun rights. It did not. This is the language fight. And I apologize for all these fucking tangents, but it's been a while. And I have to lay some of these out. Again, Bruen did not expand gun rights. The Second Amendment was written and implemented at a level that is so broad as to be hilarious, like actually funny. What guns were legal when the Second Amendment was passed? All of them. All of them. Yep, anything, including cannons, battleships, repeating rifles, all of these things that existed, they're all legal. They're all there. They're like, okay, so Second Amendment's out. What can you own? Yes. Yes is the answer. So to say that any decision that limits the infringement on the Second Amendment expands gun rights is just a nice sophistry that's done by the sophist industry, which is the fucking, that was good. That was some good wordplay. Sophist industry, sophistry, which is the mainstream media and the way they try to frame gun rights is something like, well, the government is letting you have more. Supreme Court is opening wider so you can fit. It's like, no, we're stopping them from closing off the right. It's not an expansion of gun rights. And the war of language is so important because I know people who think that Bruen was an expansion of gun rights. I know this would be a thing where it's like the government implements a law that says, sorry, you have to go to prison for 2 years at some point in your life. Like, you have to go. The Supreme Court would come in and strike that down. They'd be like, they're expanding liberty rights. Like, nope. No, that's not an expansion of liberty rights. It's just recognizing that the other law was stupid. That decision led U.S. District Judge Catherine Menendez not the Menendez brothers. They killed the parent, to reluctantly strike down the Minnesota law in March 2023. These judges, like, oh, God, I don't want to do it. I don't want to strike down the law. I guess I just have to. Oh, God, what am I going to do? Reluctantly. She also granted the state's emergency motion for a stay, keeping the ban in place until the state's appeal could be resolved. Like, whew, these 18-year-olds are going to be walking around. If I don't put in a stay on this, like, the 18-year-olds are going to be just running around the streets, burning it down to the ground. No, wait, that was 2020. Her ruling was an example of how the 2022 Supreme Court case known as the Bruen decision upended gun laws nationwide, dividing courts and sowing confusion over what restrictions can remain in force. Restriction. The Bruen decision, which was the conservative-led high court's biggest gun ruling in more than a decade, held that Americans have a right to carry firearms in public for self-defense. And it established a new test for evaluating challenges to gun restrictions, saying courts must now ask whether restrictions are consistent with the country's historical tradition of firearm regulation. Yes. Yeah. Yes. It did that. That was the right thing. That was the right thing to do. It's embarrassing it took this fucking long. Logan Orr says, your wife has had more guys run through her than an Olympics finish line. Have you considered a Jack Murphy beard? Well, that's just not true, my friend. The expert says, great show, Nick. Love falling asleep with you. Wait, you too, buddy. You too. Here we go. In his petition, Ellison requested that all the judges of the Eighth Circuit, rather than a 3-judge panel, rehear the case. He said He said many other states have laws similar to the one Minnesota tried to enact. It's like, what other states are doing it? Well, yes, but they shouldn't be. They shouldn't be doing it. And of course, this is how these things end up getting resolved. You create a disagreement amongst appeal circuits, and then the Supreme Court will have to resolve that disagreement because laws are supposed to be federal when they involve a federal right, have to be uniform across the United States. But first, you have to create the circuit split, and then the circuit split has to be resolved. Minnesota had argued that Second Amendment protection should not apply to 18 to 20-year-olds, even if they're law-abiding. The state also said people under the age of 21 aren't competent to make responsible decisions about guns and that they pose a danger to themselves and others as a result. Which, again, what is magical about the age of 21? How many 21-year-olds do you know are miraculously competent? It's like 20, they're just a bunch of shitheads running around, but they hit 21 and bam, they're nailed it. But the appeals court said the plain text of the Second Amendment does not set an age limit, so ordinary, law-abiding young adults are presumed to be protected. And it said crime statistics provided by the state for the case don't justify a conclusion that 18 to 20-year-olds who are otherwise eligible for carry permits present an unacceptable risk of danger. So again, it's just something that they made up. Their stats didn't back it up. St. Paul police investigating fatal shooting. Oh, God. Probably by an 18-year-old. But yet again, we're just stuck with the endless concept that they need to regulate further. They need to regulate further because they haven't regulated you hard enough today. They haven't. And once this succeed or fail, it doesn't matter. There's always something else to do. There's always something else they're going to have to regulate. Anytime anybody talks about the founders, they would roll over in their graves at X, Y, or Z. The main thing they would roll over in their graves at is just how fucking intrusive government has become in our lives. How many laws and regulations there are that the average citizen is supposed to keep track of. They did not build a country where every decision that you make has to be second guessed for legality. They built a country that presumed you were a legal, innocent actor. And that only a gross violation, typically of the rights of someone else, not the rights of government usually, would merit a deprivation of your rights or your liberty. But now, everything you do. Again, there's that book, 3 Felonies a Day, which talks about just how susceptible the average, not the Nick Rekieta version, the average person out there is to the whimsy of government. The average American is subject to 3 felony charges a day if someone just chooses to prosecute you. Cool Boy 52 says, Nick, I'm ironing my shirts for the first time ever. My mom is dead. Any tips, buddy? On the shirts, not mom. I was going to say ironing mom out is easier when she's dead. Sometimes they get a little wrinkly, like older moms or whatever. And they want to get the smoother skin. Once they die, you can iron them and that's better after they don't feel it anymore, I think. But ironing shirts, dude, my tip for that is buy shirts that don't need ironing. Or just wear them wrinkly. Who fucking cares? Until you have something important to go to, then I guess iron them. Do you really not know how to iron? I assume there's a deep joke in here that I'm not getting, but maybe not. Didn't you learn how to iron in 9th grade or whatever? They forced us to learn how to iron. It made me do it. I used to iron clothes for I think it was 25 cents a shirt or something for my parents. Because when they do the slave wages for kids or whatever, do this disgusting or really arduous task around the house. And then they're like, here's $1. You're like, that took me 5 hours. Ironing 4 shirts didn't take 5 hours, but I'm being hyperbolic, but you know what I'm saying. Ty says, throw it in the dryer. That sometimes works on some shirts. Or you get a steamer, those like stand-up steamer things, and then like you steam it for a while, and then you realize that that doesn't actually get like a good creased wrinkle out, and you would have to throw it in a dryer anyway or iron it, but you could try all of that. Or just hang it up in the bathroom and take a steamy shower to the sultry sounds of me. The Squid says the correct term regarding the Bruen decision is restoration, or at least one step closer to restoring our rights. Yeah, or just protection, preservation, any of that shit. Any of that shit would work. All right, we're going to get rid of this stupid Keith Ellison art. It's just illustrative. Keith Ellison joined that, who is the tech support attorney general of Illinois? Was it Illinois or Indiana? Might have been Indiana. You know what I'm talking about? He led the whole like, he led a giant case against the 3D printed guns, I think, against Defense Distributed. Gruel. Gruel, former Attorney General of New Jersey. This is what I'm talking about. See that? Hold on. This guy right here. Oh, shit. Here you go. This guy. I'm coming for your guns. This guy came after your guns. Well, the 3D printed guns. He was the Attorney General of New Jersey, and like a whole bunch of states signed on to it. God, that guy sucks too. All these people are terrible. Can you imagine? I don't know. Damn it. I'm sorry. Slapped it. I can't imagine spending my life like, how do I take something from someone else today? Like, how do I use my power to take something from somebody? Like, I don't like, there's too many of these rights going around. We need to fix that. I'm going to sue somebody for that right now. That's a weird thing to me, but hey, I don't know. I don't have the same mentality that these people do. And that's an important thing for you to remember out there in life, is you do not have the same mentality that these people do. You don't have to be as ridiculously like freedom oriented as me or whatever. You just need to understand these people do not believe that you deserve anything in your life unless they say it's okay. And that's a hard concept to get around. And the people who think that way will surprise you. But when you really get down to it, you'll find that a lot of people's, I guess, recognition of your rights depends heavily on your possessing the right opinions or the right perspective. And I say the right perspective in quotes because they need your compliance. And if they don't have it, then you don't get the thing that they don't want you to get. And you don't think that way because you wake up, you go to work, you take care of your house, you do whatever you're going to do. You go like to the library and drink beer in the back. I think that's what libraries are. And then you go home and you go to sleep and you do it again. And that's your day. Their day is wake up and then figure out something they can take from people who aren't them for some reason. And once you start to realize that that's who these people are and that's what they do, and that is their actual mentality, that is how they think, that is how they believe the world should operate, is that they will be the permission granters for your activity and the permission deniers for their perception of your bad actions. Once you realize that they're fundamentally different from you, then you can start understanding just what we're up against. So, all right, let's get away from this random Gruel story. Gerbier Gruel. The problem with my Windows PC. Okay. Now let's talk a little bit more guns, but this time as I intended to talk about in the US Supreme Court. Fuck off. Supreme Court declines to hear a series of challenges to laws barring felons and drug users from having guns. So this is Hunter Biden's long play violin as his very hopeful U.S. Supreme Court case. Well, I don't think it was his, but a case that would have had an impact on Hunter Biden's case has been ignored by the Supreme Court, leaving some ambiguity. See, the Supreme Court, as much as the media would have you believe that the Supreme Court is out here just making the Second Amendment a reckless weapon, the Supreme Court really, really fucking hates dealing with Second Amendment issues. They really do. And so they avoid them. I mean, prior to Bruen, which is 2022, the last major Supreme Court decision on the Second Amendment was 2010, which was McCullough, State versus McCullough, I think, in Illinois. And then prior to that was 2 years prior, 2008, DC versus Heller. These two cases were about the right to have guns in your home, like in your own house, not keeping and bearing them out in the street, but just in your own house. Can you have a gun assembled? And they said, yeah, I guess the Second Amendment allows that. And we're all like, obviously, but it wasn't obvious, I guess. And Scalia wrote this very tortured decision that allowed us to do that. But hey, but you got to think about it. That's 12 years between the last major Supreme Court decision on the Second Amendment and Bruen. And once Bruen happened, they're like, oh my God, they're rewriting the entire Second Amendment. And now the court's like, whoa, we got to back off on all these Second Amendment cases. But they take other amendments, they take cases in droves every year, not the second. The Supreme Court said Tuesday it won't take up a challenge to parts of a federal law that bar convicted felons and drug users from possessing firearms and let stand a ban on assault-style weapons in Illinois. So again, the Supreme Court now is like, yeah, assault weapons ban, that makes sense. And they did this last time too. They did this under Clinton back in the 90s. They're like, yeah, of course you can ban assault-style weapons. Well, what's an assault-style weapon? Whatever you want it to be, bro. That's just what it is. It's the weapons that do the assaulting, apparently. But they're going to let that stand, even though the Second Amendment doesn't make distinctions around assault-style weapons. And there is no objective assault-style weapon. It's not a thing that exists. There's no accepted codified definition where you can go, that's an assault-style weapon. You can kind of guess because if it looks fun or cool or like has racing stripes or whatever, it's an assault-style weapon. Because if it would make a white woman angry, it's an assault-style weapon. Like that's become the standard, right? Not all white women, right? Like just the ones that complain about. I don't know how to reverse out of this mud pit. But the other part is the convicted felons and drug users. One of the big questions, again, with the Second Amendment is why is someone who's a convicted felon automatically banned from their Second Amendment rights? Now, it makes sense for assaulters, murderers, robbers, things like that. It's like, oh, you use weapons and like harm people or whatever. Maybe you shouldn't have Second Amendment rights for some period of time or maybe ever, depending on how bad you are. That at least has a logical connection to the ownership of a firearm. Firearms allow someone with malicious intent to do a lot of damage really quickly, right? Like we can at least see the connection between them. But what about someone who commits like securities fraud? Like Martha Stewart. Why can't Martha Stewart own a gun? Like she's just like, somebody told me to sell stock and I did, and I made money. And they're like, haha, go to prison and no guns. And Martha Stewart's like, but I hang out with Snoop now. I might have to shoot somebody. And where is the logical connection there? Why is your Second Amendment forfeit for like a white collar crime, for example? Or it doesn't have to be a white collar. It could be a hardworking blue collar crime that just doesn't involve roughing people up. What is the purpose of taking the right to keep and bear arms away from someone because of some crime unrelated to violence or guns? It doesn't, or knives or swords or whatever. The Second Amendment is not limited to guns. It's just, that's where pretty much everybody goes. But like, why is your right to brass knuckles impacted by your hacking crime? You weren't wearing brass knuckles while you were typing unless you're really cool. So why would that happen? but it does. And we're just fine with that. And then of course, drug users is another big one. This is, this has been the issue that that gun rights activists have been lately targeting, especially since Bruen. There's an ambiguous question with federal marijuana law right now, where marijuana is a controlled substance. I don't know if they've been rescheduled to Schedule 3 yet, but it was a Schedule 1 substance forever. But states had legalized marijuana kind of across, I think it had hit a majority of states. And so you go, wait, in my state, it's legal to use marijuana, but it's not federally legal. So then when I go to buy a gun and the form says, are you a user of an illegal drug? Do you check yes or no? Right? Like, do you like me? Yes or no? And then people have to ask the question, was like, well, am I an illegal user of a controlled substance? If it's marijuana, it's legal in my state, but federally illegal. The safe legal answer is you'd have to check yes, and they can't sell you a gun. You can't buy one. And it would be illegal to own one. That's right. If you're a pot smoker and you have a gun in your house, well, you're committing a federal felony. Have fun with that. Actually, I shouldn't call you a pot smoker because the term user, drug user, is ambiguous. What is a user? If you smoke pot once, are you a pot smoker? Are you a drug user? What if you smoke it like once a week, once a month, once a year? When do you stop being a drug user? These are all questions that aren't federally answered. And again, when a state legalizes something that's federally illegal, however unenforced, what is it? What's the answer there? I don't know. Nobody knows. But the real question now under Bruen, and this is why they've been going after that, is, wait, why do you even get to fucking ask? Where in the Second Amendment does it say that a drug user cannot purchase a firearm or own a firearm? Where does it say that? It's like, shall not be infringed. Well, unless they're a user of drugs. I mean, unless then, but that's not written there. People they made it up. And they assume that. So these things are being challenged. These are the big ones lately is, again, nonviolent felons. And that goes back to Amy Coney Barrett. If you remember at her confirmation hearing, she had written a dissenting opinion in a prior appeals case that basically said, why does this guy convicted of white collar crimes lose his gun rights if he's nonviolent? So people were like, oh my God, they're going to give felons guns. It's like, well, I mean, a felon, believe me, violent felons who want guns, they're going to get them. They're just going to have them. It's not that big of a deal for them to do it. It's over and over again. We find that a violent felon still comes into possession of a firearm when they want one to do more violence. So the law shockingly doesn't stop convicted felons from getting more convicted felon gun charges. It just doesn't tend to block that. But convicted felons and drug users are these classes that don't seem to be contemplated at the time of the drafting of the Second Amendment or the 14th Amendment, when there would be some sort of historical analog to this restriction. So that's been the challenge. The court is punted on this issue. The decisions come days after the High Court upheld a separate provision of the same federal disarmament law in the biggest Second Amendment case to reach justice in 2 years. Court's majority said a restriction on domestic abusers, this is the case we were talking about with Ellison, possessing firearms was constitutional because it was in line with the tradition of firearm regulation, disarming dangerous individuals. And yes, again, from the time of the Second Amendment, if someone was found to be a dangerous individual by a court, yeah, you could take their dangerous weapons away from them. You'd also take their liberty from them. And actually, at the time of the drafting of the Second Amendment, a violent felon, had a potential death penalty for every single crime. Every single felony had a potential death penalty attached to it at the time of the drafting of the Second Amendment at the federal level. And so that's certainly within the historical analog. But the question is, if you're nonviolent, where's a specific, and this gets into be a more complicated discussion because it requires you to understand that the amount of felonies that existed back then was very few. It's not like now where there's like 10,000 different felonies in U.S. code. But Okay, so weeks after the Second Amendment featured prominently on the court's docket, the decisions on Tuesday amounted to a collective ducking of the issues of guns when the court returns in the fall. Among the cases the court declined to hear is one that could have unraveled Hunter Biden's federal firearms conviction. And of course, I think that's probably one of the major reasons that the Supreme Court stayed away from this one. If the Supreme Court takes on this case, it has a political bent to it no matter what. Now, maybe they should have done it because then that would have tested the conservative versus liberal on gun theory. Because if you're saying, well, the liberal justices will stand up for Hunter Biden and the conservative justice would go against them, maybe they should have taken it at that point. I think they just wanted to avoid this issue in an election year when it directly impacts Hunter Biden. But Hunter Biden is, of course, charged with owning a firearm as an illegal drug user. Convicted, I should say. The court sent the challenges to the federal firearms ban back down to a lower court with instructions to review the case in light of their ruling last month in U.S. versus Rahimi. So the court is going to send them back. The appeals courts are going to send them back to the Supreme Court. This just pushes the ball down the road like a year, maybe 2 years. In that case, Chief Justice John Roberts, writing for an 8-1 majority, said that a 2022 ruling from the court that changed the framework federal courts must use when examining the nation's gun law did not necessarily lock lower courts into striking down any gun law that didn't have a direct historic analog, which of course it didn't. That wasn't what the ruling said, and that should have been obvious. Some court watchers had speculated that the court's opinion in Rahimi might address laws disarming felons, but the majority avoided directly wading into the legal debate over whether other federal gun prohibitions, including the one at issue in the present controversy, would also be upheld, at least for now. The court seems unwilling to jump right back into the messy fight that it touched off 2 years ago in the Bruen case with respect to exactly what the Second Amendment does and doesn't prohibit. Now, listen to that for a second. What the Second Amendment does and doesn't prohibit. You know what the Second Amendment prohibits? Any infringement on the right to keep and bear arms. Any, all of it. It shall not be infringed. The right of the people to keep and bear arms shall not be infringed. So that's what it prohibits. And again, that's the important distinction that needs to be made. There are points where someone forfeits their right to do something. You forfeit your liberty when you egregiously infringe on the law enough to go to jail. That's when you forfeited your liberty, your personal right to move around, right? It's not that there's not an infringement on the right of liberty by having a punitive incarceration system. The infringement on the right to liberty would be restricting a class of people or everybody just as a matter of course. That's an infringement. And that's what these restrictions on gun purchases, gun ownerships are. They're not someone forfeiting a right. They're a right being restricted to a class of people based on a status or condition. And typically speaking, a deprivation of liberty has a specific nexus to the liberty that is impacted. The Noble Weeaboo says, real Second Amendment question, not trolling even a little. Can a vehicle be considered arms? And would that make a licensure and regulation of vehicles a violation under Second Amendment? It could be in theory, but they're not. So yes and no. There's your very ambiguous answer. But certain vehicles may actually be arms, right? Like you can imagine that some vehicle, like a tank, for example, could be an arm regulated by the Second Amendment, hypothetically speaking. It would be a weapon specifically for some purpose. But generally speaking, like a vehicle, a car is not like intended to be a weapon of defense or, offense. I mean, unless you're really cool. You have one of those cool battering rams. All right, back to this. So yeah, what the amendment does and doesn't prohibit, said Steve Vladeck, CNN Supreme Court analyst and professor at Georgetown University Law Center. But the punt here is necessarily temporary. Lower courts are already bitterly divided over how they're supposed to review a number of different state and federal gun control laws. Vladeck added, it's a good bet that before their next term is over, the justices are going to have to step back in. Yeah, there's going to be the circuit split here is going to be quick, as relative to how quick these legal issues go, and they'll have to take it up. Of course they're going to. My theory is they just really don't want to do it in the middle of an election year. They don't want it to be an obvious campaign point. The court is reeling from the politicized moniker that it has, and Roberts is trying to pull the court away from politics, despite the fact that all the media plays are like, Roberts is trying to politicize the court. No, he's trying to do the opposite. He always has been. His entire mantra has been to depoliticize the Supreme Court as much as possible. Just because his own nomination was bitterly political. But that being said, that's been his sort of goal as the Chief Justice, is to take the court away from politics. He hasn't done it successfully because the media wants it to be a political court. They want these political issues to dominate the headlines because they frankly fucking sell ads. They sell ads. So, as long as that happens, the Supreme Court will be political. But I think they're trying to pull this out of the election year. Once the election's over, they can go ahead and get back into the issue. The decisions to take or deny cases in the so-called cleanup list came a day after the Supreme Court handed down the final opinions of a contentious term, including the decision to grant sweeping immunity. It wasn't sweeping immunity, actually, to former President Donald Trump. The court also dodged a number of other high-profile matters, either by declining them outright or sending them back to lower courts. The justices, for instance, declined an appeal challenging Section 230, controversial law that provides legal protection to social media companies for posting third-party content. And it waived off a challenge about whether the Department of Labor can enforce workplace conditions on American businesses, an appeal that could have further weakened the power of federal agencies. While that case was ostensibly focused on one agency, OSHA can get fucked, by the way. The political and legal underpinnings were far deeper. Conservatives have for years sought to revive what's known as the non-delegation doctrine, the idea that Congress can't hand off legislative decisions to the executive branch. A ruling against the Labor Department could have had profound implications for the balance of power between the branches of government. So the non-delegation doctrine is this, again, it's exactly what they said. Congress goes, we don't want to do this. It's our enumerated power, Article 1, Section 8, sometimes Section 9. It's our power to do this, but we're going to create a government agency under the executive branch, and we'll tell them they can do it instead. So now unelected officials are doing what elected officials are supposed to be doing, while elected officials are getting blowjobs from pages all over the entire fucking floor of Congress. And that's what they want to be doing, right? Like, that's what they're happy to do. They don't want to actually do this hard thing of using their political capital to govern and make decisions and then have consequences for them. They want to give all that power to unelected bureaucrats and let the bureaucrats do everything, take all of the fallout, but have no consequences for it, while they just reap the rewards of being America's ruling class. That's what Congress is. That's what Congress wants. They have to do something to justify their jobs, but they never have a consequence for fucking doing anything, because what they do is just create places where other people affect your life. OSHA being a huge one. Anybody who's worked in any job that involves any mild amount of labor. Like if you have to climb up a ladder in a store where you otherwise just loaf around like Stephen Hawking, you'll still have some fucking OSHA regulations and a bunch of posters up in the break room. Like, I'm just trying to pee in the chili here. I don't actually want to read an OSHA poster while I do it. Don't pee in the chili. So disarming drug users. The case related to Hunter Biden, US v. Daniels, was being closely followed because he was convicted in June of violating the same disarmament law at issue in the case, as well as 2 other federal firearm laws. His attorneys have consistently pointed to the Daniels case, in which a federal appeals court said the law was unconstitutional as they sought to challenge his prosecution. Biden's attorneys are expected to lean on the appeals court ruling as they raise a post-conviction appeal. And I mean, this is the thing, frankly, that matters here, is that where does the Second Amendment say not drug users, though? PPP1 says topic sucks. Cool. William Dixon, welcome to Super Lawyer Status. Thanks for joining, buddy. Patrick Daniels was stopped in 2022 for driving without a license plate. A search of the car uncovered several marijuana cigarette butts, a loaded pistol, and a loaded rifle. The officers did not administer a drug test the night of the stop, but Daniels admitted that he was a frequent user of marijuana. Oh, why would he do that? A federal grand jury indicted Daniels for possessing a firearm as an unlawful user of a controlled substance, and a jury convicted him of violating the firearms law. So there you go. This is a guy who's like just driving around. He's like, yeah, I use weed like all the time or whatever. And they're like, well, sorry, now that you have use weed. Oh my God, I watched Reefer Madness. You're probably murdering everybody. He had initially challenged the charges before conviction, citing Bruen, but a federal judge denied his request throughout the indictment. Wasn't that nice? The federal judge, he's like, no, you can pay for an expensive ass appeal. A New Orleans-based appeals court later reversed, ruling last August that the law was unconstitutional as applied to Daniels. Quote, in short, our history and tradition may support some limits on an intoxicated person's right to carry a weapon, but it does not justify disarming a sober citizen based exclusively on his past drug usage. And this is what I was alluding to earlier. What is, and I think this is just a vague, an issue of vagueness in 922G. What is a user of a controlled substance? Like what makes them a user? At what point do they stop being a user? And that question isn't answered anywhere. There's not an objective standard for it. Circuit Judge Jerry Smith, a Ronald Reagan appointee, wrote for the 3-judge panel, nor do more generalized tradition of disarming dangerous persons support this restriction on nonviolent drug users. Okay, so now we've got the Illinois ban on assault-style weapons remaining in effect. But just a brief one again, 922G just creates this ambiguity for anybody. At what point, like let's say you've never owned a gun in your life, but you're a drug user. At what point do you could say, well, I'm no longer a drug user, so now I can buy a gun? And the answer to that is probably never. Because how do you prove you're not a drug user according to the federal government? Remember, like this guy just had marijuana butts. Now he admitted that he was a frequent user of marijuana, but there isn't a thing that says at some point you stop becoming a user. There isn't like, well, it's been 6 months, it's been a year, it's been 10 years. I mean, I would think someone who hasn't used drugs for maybe like a year would probably not be a user. I mean, if we want to get really into it, I think someone who just decides to stop using drugs is no longer a user, but people would say that they can't decide to do that or they might relapse or whatever. Sure, I guess. But what point? There isn't an objective point. It makes this law ambiguous. It makes it a question of when you go to purchase a gun, that 922G is the possession ownership. But when you go to fill out your permit to purchase form, right, and you have to check the box, it makes it an ambiguous answer. You don't know if you're committing a crime. You don't know when you can say you're not a user of a controlled substance, because if you are a user of a controlled substance, you just tried to illegally buy a gun. And if you're not a user, or if you say you're not a controlled substance, the federal government just disagrees with your definition, then you've committed a crime as well, because you've now lied on a government form. This is really, in my opinion, 922G is just a product of bad fucking drafting. And I'm not sure that they'll even eventually eliminate it entirely. I think they should, but I don't know that they will, because they may be able to narrow the scope of it by just defining what a user of an illegal substance is, like create some standard for that. And then maybe the federal government would have the ability to enforce that. But right now, to me, it's just far too ambiguous. So Illinois ban on assault-style weapons remains in effect. The other cases the court declined to hear include ones challenging an Illinois law that bans semi-automatic weapons with certain features, such as those that have detachable magazines So that's your first assault style weapon is a detachable magazine, which I don't know if you know this, but that's basically every fucking magazine. And also pistol grips, flash suppressors, or removable stocks that make them easier to conceal. Right, because if you've got an AR-15 and it's this big, and you can make it this big, now you can conceal. Like it is technically easier to conceal if you remove the stock, I guess. But it's not like it's, oh, now it fits in my pocket or whatever. the, the lack of just basic logic involved in gun regulation always fucking throws me, because it's like, well, it's easier to conceal because technically it is slightly smaller, but it's not like it's not like, oh, now I can shove it in my shoe or something. It's still a big fucking gun. Justice Samuel Alito, among the court's stalwart conservatives, said he would have granted the Illinois cases dealing with the assault style weapons, but did not write to explain his reasoning because he thinks it's bullshit. That's why. Clarence Thomas, also a conservative, was the only member of the court who wrote on the matter. Quote, "We have never squarely addressed what types of weapons are arms protected by the Second Amendment," Thomas wrote. "The minimal guidance the court has provided on the issue is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual." Now, Thomas here is citing back to Justice Scalia's opinion in DC versus Heller. What is actually an arm contemplated by the Second Amendment? Scalia intimated that there are some guns that fall outside of the classification of arms, and those would be dangerous, unusual, or basically exclusively reserved for military purpose weapons, which is the opposite of US v. Miller. But hey, who's counting? It's a really, really, really fucking weird sort of concept here, because the right to keep and bear arms, what is, again, dangerous, unusual, or military specific? How does that make them not arms? That's the part that I don't get to. It's like, well, these are outside of the Second Amendment's purpose. Like, well, where? And you could try and read through Scalia's like reasoning on it, but the good news is that Thomas properly says that, his good friend Scalia, who wrote the opinion, he's like, he intimated that there's these classifications, but he didn't provide a comprehensive framework. And the court will need to do that at some point, because right now, dangerous and unusual weapons are outside the scope of arms contemplated by the Second Amendment. Well, what makes them dangerous or unusual? I don't know. They blow up, I guess. They're not usual. And it's amazing because this would be a perfect case to test that, right? What about an assault style weapon? Let's see. Does it sound familiar? Detachable magazine, pistol grip, flash suppressor, and then a detachable stock. That sounds a lot like an AR-15. The most common the most common rifle in America is an AR-15 style rifle, which would fall under the assault style weapons definition typically. So it's like, wait, but the amendment would specifically cover like the most common rifle. Like that's what the amendment would be supposed to be, protecting the right to own. That's inherently not unusual. So this would be a good case to analyze that and develop out that framework and say, hey, but everybody, they have to agree to take the case, and not enough people did. Gun rights groups have framed bans on AR-style semi-automatic weapons as unconstitutional, particularly in light of blockbuster Supreme Court decisions in recent years, vastly expanded the scope of the Second Amendment. Again, it's such the opposite. They argue the weapons banned under laws are common. Hey, wait, I was just saying that. And that labeling them assault weapons is nothing more than an argument advanced by a political slogan in the guise of a definition. Yes, exactly. Exactly. Let's see. We've got, there's a chat here. Rumble. Tenshi92 says, what do you think about Destiny's insurrection arguments? Seems he went further into it since y'all last talked. Oh, did people like watch? Guys, I don't watch Destiny. I don't know what his insurrection arguments are. If anybody wants to elaborate on that, I could try, but I don't know what Destiny's insurrection arguments are. Destiny, when he talks about constitutional issues, I just have to think he's listening to Pisco, and Pisco's retarded. So I'm not sure, but Destiny's arguments about constitutionality, presidential power, presidential immunity. I mean, routinely he's been on a strange side of it. I'm not sure what his insurrection stuff is. Twitter DMs again. What is this about Destiny? But what if I don't want to talk about Destiny's? Here we go. Police bust Comic-Con sex trafficking ring in San Diego. Arrest 14 people. What does that have to do with Destiny? Sex trafficking at Comic-Con? No. That wouldn't happen. Can I pull up the story? Like, there's the headline. Where's the fucking story? Here. I might look at that in a little bit, but not right now. Sorry, Jim. All right. Do we want to read about no? Well, we're almost done with this. Let's finish up this this article here, because I do think just going through what the court is ignoring is pretty important. New York's concealed carry gun law. The Supreme Court also declined to hear arguments from 6 New York residents challenging the state's recently approved regulations on carrying concealed firearms, including in sensitive places such as schools, parks, and concert venues. The decision to send that case back to lower courts for further review leaves in place most of a New York law approved in response to Second Amendment blockbuster ruling 2 years ago. Again, Bruen was out of New York. And so they passed another law that says, well, you can carry them, just not in sensitive places, which covers a lot of New York. The legal fight over the new law will continue in lower courts and could return to the Supreme Court. Bans on felons possessing guns. This is the bigger one. People are uncomfortable with this. People are very uncomfortable with the ideas of felons owning guns, but that's just because when we hear felon, we often think of violence as part of it. Well, I shouldn't say we, I don't, but I used to. So here we go. The felon disarmament cases involve individuals who are challenging their convictions for violating a federal law that prohibits felons, both violent and nonviolent, from possessing a gun. People at the center of those disputes included a man who pleaded guilty in 1995 to a single misdemeanor charge of welfare fraud under Pennsylvania law, and a man whose criminal record included convictions in Iowa state courts for theft, aggravated use of a weapon, aggravated assault, and intimidation with a dangerous weapon. See, now this one, right? This one kind of seems like maybe there's a reason to say you don't get to have a gun anymore because you keep using dangerous weapons for assault and intimidation. Like maybe that's a reasonable restriction. The other one, though, a single misdemeanor charge of welfare fraud. Some of those cases, the Justice Department told the court that it needed clarity on whether that felon disarmament law is constitutional, given how frequently it brings criminal cases under it, pointing to some 7,600 cases from fiscal year 2022 alone. That's a lot of fucking cases. The present conflict is unlikely to resolve itself without further intervention by this court, Solicitor General. Now, I mean, just think about this. There's 7,600 cases from fiscal year 2022. That means 7,600 prosecutions, not 7,600 incidents of nonviolent felons, potentially nonviolent felons, owning guns and being potentially in violation of this law. That's just this limited subset of the act. And so again, it creates an ambiguity. People think, why is my right infringed? Or they just think I want guns because they're cool. Present conflict is unlikely to resolve itself without further intervention by this court, Solicitor General Elizabeth Preliger told the justices in court papers, adding that disagreement among lower federal courts about the law's constitutionality is undermining public safety. District courts have struck down the felon disarmament law, even as applied to exceptionally dangerous felons, including murderers, carjackers, and drug traffickers, and in some cases have ordered that the defendants be released pending appeal, Preliger wrote. Now, see, this is a question. There's always a question when there's a hotly contested political issue and courts make seemingly non-pragmatic decisions, right? Those decisions where they're like, well, we'll just let the murderers out seem kind of like a protest ruling, right? Like, I'll show you, I'll let them out. Who cared if they murdered 48 people with a gun? They get their rights to a gun forever. It's like, well, I mean, I don't know that they do. I don't know that anyone thinks that they should, but that's the way some of these judges do this. They're petty. They're petty, and they go, well, I'll punish the society by doing it. But it's kind of interesting because as much as I get that concept, I'm not sure if it's a punishment to society to just expand the liberty of someone. And that would be an expansion of liberty because, again, it's been, if you're a murderer with the dangerous weapon, there's a historical analog to taking your gun away and your life. So speaking of taking lives away, this is way off topic, but it's really interesting to me. Did you guys see that they finally got a plea agreement? A plea deal has been struck with Khalid Sheikh Mohammed. Yeah, KSM, the DJ who they waterboarded like 5,000 times for like being part of the 9/11 plot or whatever. Now, they arrested that guy back in 2003, and he's still at his pretrial hearings. My man is in pretrial for 21 years. Khalid, and they famously waterboarded his hairy shoulders like 168 times. Or maybe it was 186. Let's see if I can find a picture of that. Khalid Sheikh Mohammed waterboarding. The 9/11 crew. He was one of the planning committee on the 9/11. Like, he was one of the, like, do you think they use like Robert's rules? Like, at a motion, we hit the Twin Towers. Second. That gala la 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 thing has got to be. Hey, this guy looks like I did on my live stream on May 21st. Look at him. Oh, God. It's like Ron Jeremy had a glow up. Ugh. Bro, you're wearing a sweater under your t-shirt. Is his t-shirt upside down? Look at how wide the neck hole on that t-shirt is. Oh, his neck hole on his t-shirt is named Stormy Daniels. Whew, it's a blown out neck hole. Jesus. Oh, that's a rough day, man. That is a rough day. He does not look like he was doing okay after that. Wait, why does he have a red beard in this drawing down here? His shifting beard colors are awkward. Oh, anybody who says waterboarding isn't torture, like, he's like, oh, you fucking bet it is. This guy drank the last Budweiser in Dylan Mulvaney's collection. Oof. But yeah, so this picture was so old. How does he look now? Wait, I like this one. This one, he looks like a contemplative rock lyricist. He's going to write some 80s ballads. Ooh, girl, my shoulder sweater's going to keep you warm. What is It's a hairy breed of man right there. Okay. God. All right. I don't want to look at him anymore, but they reached a plea agreement with this guy. He's going to plead guilty to conspiracy for 9/11 or whatever for life in prison. So he doesn't get a death sentence. Which I guess is fun. Like, I don't care anymore. Do you guys care anymore? Like, it's like, kill that guy, I guess. Like, there's no major political or like declarative value in death penaltying that guy anymore. Look, guys, I've been in pretrial since May 23rd or 24th, technically. This guy's been in pretrial for 23 years. No, 21 years. This guy's pretrial can conceal and carry a firearm. He would have rather had a death penalty. It's like, oh my God, just fucking killed me right now. He would have rather had that happen than sit in pretrial that fucking long. But this makes things easier for the federal government because they just get to now like be done with it. They don't have to go through all of the problems with, wow, you held this guy for a really long time. Does he get any more constitutional challenges? But look how much deference we afford the guy who like plan 9/11, right? Like all the black guys who have like they go straight to prison. Like all the ones Kamala Harris was prosecuting or whatever for not liking her Instagram. Like all of those guys who went straight to prison, they're like, this motherfucker. They analyze his rights forever. And seriously, that's what it is. Khalid Sheikh Mohammed's rights being analyzed is what has taken 23 years for his prosecution. And like, they don't give a shit about American citizens' rights in the criminal justice system and analyzing them in the depth that they are. This guy, they're like, oh God. And like, are we doing okay with this guy who planned to like, plan the murder of thousands of Americans and brought our country like to economic disaster, created basically a response that would launch 2 decades long wars and trillions of dollars of expenditure. And like, well, yeah, are we recognizing his rights hard enough? He's not even an American citizen, by the way. We just grabbed him from some other country and we're like, oh, put him in a bag, big hairy bag. They put him in a big hairy bag and they dragged him somewhere else and they poured water all over his mouth. Some people pay for that. And they're like, God, are we protecting his rights hard enough? And then pretty much anyone in the U.S. criminal justice system who's an actual American citizen's got to be like, hey, wait, what the fuck though? I feel like this guy has more rights than me. And he does, by the way. It's actually, there's a couple rulings, but foreign enemy combatants captured in a foreign enemy combat zone, they have more rights than an American citizen who is deemed an enemy combatant captured in a combat zone. And actually an American citizen in a non-combat zone, like, what was his face? Anwar al-Awlaki, he has even less rights. So Khalid Sheikh Mohammed, the foreign enemy combatant mastermind of the 9/11, well, the other mastermind, because like Osama bin Laden was the other mastermind. There's probably another one in there somewhere, but one of the masterminds of 9/11, he has more rights than you do for rights to habeas corpus, rights to civil jury trial, a criminal jury trial versus a military tribunal. Rights to not be tortured. This guy has more rights to not be tortured than you do too. That's a fun set of rulings from the Supreme Court. Thanks. Hamdi versus Rumsfeld, US v. Hamdan as well. I think those are the 2 main ones. There's another one, US versus Gonzalez, maybe. A little rusty on that national security law. Don't have to use it too much out here in Spicer. But yeah, isn't that nice? Like, oh, we really care about his rights, but yours, well, you know what? Fuck you if you tax evaded at one point. No guns. Veterans Farming Initiative. Hey, what's up, man? Guys, Veterans Farming Initiative. Very, very cool. Very cool farm. Helping veterans or whatever. They have great food, great products. They sell meat and they sell like little microgreens and they sell vanilla. The vanilla is delicious, by the way. Vanilla extract, a whole bunch of stuff. Got to meet them. Very, very cool individual. Very, very cool business. And make sure if you're in the Minnesota area, check out the Veterans Farming Initiative. Drop Barracuda says American justice system. I can fix him. Well, he is. Look at him. I mean, he's a handsome devil. Right here. Do you think? You know what? Okay. I'm going to propose an alternative. I mean, it's still a life sentence. It'll take a while, but they should just remove all of his neck and shoulder and body hair by tweezer individually. Like, don't death sentence him. Just sentence him to that. Like someone like make another one of the like Islamic guys or bad guys or whatever do it. Like make him sit there and use tweezers and pick this guy's back hair like a monkey in a zoo. Right? Make some other guy eat it or whatever. Just do that. That would take for fucking ever. And it would be so goddamn irritating. Just fucking decades. You know, you get one shoulder done, the other one start growing back. Ew. Gross. Oh my God. Let's see who we can offend. Wait. Oh, I like this one. Can we do it? Can we do it? Let's try this one. We're gonna have a word from today's sponsor, which is 5G free ultimate radiation defense. Protect yourself from harmful radiation with proven solutions. There's a QR code now on your screen, which will bring you to 5G free. But let's see what they have to say here. Who is in control of America's nukes? Is it Biden? Kinda. Meanwhile, we have Russian ships off the coast of Florida and full-blown wars in Ukraine and Israel. The world is at its most unstable point since World War II, except now. With nuclear weapons, the stakes are 10 times higher. How do people like you and I stay safe? Luckily, we've got a solution. Every prepper needs to have Radio Guard ASE, the only FDA-approved drug to treat radioactive fallout. That's right, ladies and gentlemen, just like in Fallout 3 or 4 or 5 or Fallout 76, because you skipped a whole lot, went to 76, you got to get your rad pills, and that is here. The only FDA-approved drug to treat radioactive fallout. Only the feds have it until now. That's why I partnered with 5G Free, the only company in the world that has a supply of Radio Guard ASE and the ability to prescribe it prophylactically. Get your prophylaxis on right here. Protect yourself prophylactically from imminent radiation. Get their radiation emergency kit with Radio Guard ASE, potassium iodide, Zofran. Zofran's pretty good. Like, that stuff keeps you from vomiting. That's good. If you have radiation sickness, you want some Zofran, because that shit, you don't want to be vomiting. And a Geiger counter. So like Egon, you can see where the ghosts are in your body. I always wanted one of those Geiger counters. There's simply no other tool in your arsenal. This is serious, by the way. No, like, you need this. I'm not even joking. I like this product. This is cool. I want a Geiger counter. No other tool in your arsenal to protect against a radioactive threat. And that's the truth. How many of you actually have tools in your arsenal to protect against radioactive threats? Show of hands. Anybody? Go to 5gfree.com. That's 5G, like my homies, free.com/studio, and use code studio to save 10%. I have a radiation kit. I do not. I want one. It says, I have a radiation kit, and so should you. Now, I don't have one, but I want one, and you should too. That's like, I do believe that. That's 5gfree.com/studio, code studio, all in capitals, studio. So guys, check that out. I'm going to have to add that to the description of the video, but that's 5gfree.com, promo code studio. That is pretty cool. I like that one. I think you guys should get that. I want to get that. Thank you for humoring me. I love sponsors for the show, and that's a fun one, man. All right. Deus Ex Machina Prime says it works. It works now. Talking about Rumble rants. I think they were having problems earlier. Excuse me. I'm burping. Tenshi92 says, and the J6 riot. Oh, wait, no, I'm going to read. I was reading these in the wrong order. Tenshi92. This is about Destiny. This is about Destiny. Destiny is a woman's name. Destiny claims that because the electors forged documents saying Georgia validated them as an alternative slate, that it means Trump initiated a coup through fraud. Well, that's idiotic, but okay. Look, here's what I need you to do. We're going to commit a fraud on Mike Pence. Mike Pence, not a very sharp guy, not a good reader. Look, if you just send in your slate of electors, I don't know, it's like a slate tablet. Maybe we'll chisel their names on there. We're going to send it to Mike Pence. He'll open the envelope, be surprised when slate comes out. He'll look at it. Oh, these are electors. Look, it's a slate. He'll look at it. And if you just put a little hand scrawled note that says, we were totally approved by Georgia, no one will know. No one's going to know the difference. There's no public reporting on this. Then Georgia's not going to be like, oh, you know what? Actually, that's probably our people. We're going to pull a fast one over Mike Pence. We'll hoodwink him. Hoodwink it's fraud, but it's nicer because it sounds like something that people did in the South where Georgia is. Hoodwinking. What is a hoodwink? Action. Oh, God. I just thought of a horrible thing hoodwinking could be, but I'm going to save it for locals. That joke is disgusting. You. If you think of things that might be unconventional hoods. Oh, wait. So back to 10G92, he says, and the January 6th riot was purposely incited by Trump in order to pressure Pence to accept the fraudulent electors and delay the peaceful transfer of power. No. Why would he need that? Pence is just stupid enough to just like, oh, look at this. These electors are so confusing. I'll go with this one. Again, you have to distance yourself from reality to get to the premises that people like Destiny need to support their argument. You have to assume that the Vice President of the United States, Mike Pence, in the most covered event of every 4 years on the entire fucking planet, which is the US election cycle, it's way more covered than the Olympics or anything else. There's maybe Taylor Swift and Travis Kelce's wedding is going to outdo it. But generally speaking, the presidential election in the United States every year is the most watched fucking event on the planet. Every 4 years is the most watched event on the planet. Most monitored by everybody, which is why they say it's so impossible to defraud it. And they're like, no, these guys almost did it. They almost got it. They almost pulled one over on old Mikey Pence, lightning eyes Mikey Pence. He was going to just approve it when he got that fake slate of electors because they had a note that said that Georgia approved them. It's like, there's a fraud. And Trump almost got, he's like, we're going to march down there. We're going to put up some, the old bait and switch, the old rope-a-dope, the old hoop-a-joop. Mike Pence isn't going to know what hit him. You're going to walk down the halls, the beautiful halls of Congress. Wonderful. I've been there several times. Usually I was paying them. Now they're paying me. Walked around there. They'll just walk through the halls. Mike won't know what to do. He's very confused, easily distractible, kind of like Joe when he thinks about ice cream and children, very distracted. And you're going to walk in there and Mike's going to just pass the elector. They won't even notice. No one's going to ask him. And again, you have to get to this question of who the fuck would be fooled by any of this stuff? Who thinks it's a fraud rather than what it was openly purported to be? Was it a fraud or was it just the presentation of an alternative slate of electors in case Georgia, a contested state with some very shady late hour activities? Hello, Fulton County, right? Random water main break or whatever. All these votes just coming in the middle of the night. Votes coming in left and right. So in case Georgia just decided, you know what? Maybe we looked at our election and maybe it seems weird. I don't know. Maybe we sent the wrong slate of electors because it looked kind of like some people might have done some funny business and we got the wrong thing. And again, did Georgia do that? No. Georgia looked at their thing. They said, no, we checked ourselves out and we did it right. Right? Typical government. Raffensperger or whatever. That guy's like, nope, we're completely in the clear. Georgia did everything right. And our original electors are what we're sending and we're sticking by it. We're sticking to it. We're not what's behind door number 2. Door number 1 is just fine. And that's what they stuck with. It's like, well, there was this fake electors sent and they tried to defraud them. It's like, Georgia would have noticed. Georgia would have noticed. Everybody would have fucking noticed. But they're like, no, they almost snuck it in there during January 6th. Destiny, that argument's retarded, buddy. Come on. Don't do that. All right. Drop Barracuda says, scan this QR code on your 5G dependent device. Well, I mean, maybe. Get your rad pills, man. These pills are fucking rad. Okay. I think that's enough. I think that's enough. Khalid Sheikh Mohammed. I keep looking at his picture and getting like, I really do like this picture of him. I think it's a good one. Like, it's just, I feel like I've seen this picture, but not with his like hairiness, but like in black and white and from like the 70s, some like drugged out rocker or whatever. I don't know. What do you guys think? I think it's the best picture of him. Or was this how he used to look? No, he looks way better in this other picture up here. Yeah. Okay. Anyway, sorry. I gotta stop. Like Biden with ice cream. I'm like, Khalid Sheikh Mohammed, man. All right, here we go. Should we go to Jack Smith? I brought up this article for a couple reasons. One, because talking about Jack Smith is interesting to me, and the dismissal of the Trump missing documents case, which shouldn't have been a case in the first place, by the way. I think presidents presumptively declassify things when they remove them from a secure location and move them to a non-secure location. And I think the president should have the power to declassify whatever the fuck he wants, even by like accident. But hey, that's me. That's just my thought on it. But I don't think it should have been a case for that reason. But Eileen Cannon has dismissed it because she's like, wait, this Jack Smith guy, isn't an officer of the United States. And this was an argument I've talked about a couple times. It was fronted. I think the Volok guy was a big part of it. But let's take a peek at this thing. Tenchi 92. Hold on. Destiny is convincing thousands right now. Dick is apparently going to argue with him about it soon. Wanted to give him a few pointers. Destiny is insane, but convincing a ton of idiots. Well, that's the story of Destiny's show. So, I mean, I guess. Yeah. I don't know. Maybe he'll play Factorio while talking too fast about it, and that gives him the extra credibility he needs. Okay, so this is a weird. I don't know. The headline for this thing is fucking weird when we get to the text of the story, because the text of the story like doesn't support the headline, but it says why Eileen Cannon might triumph over Jack Smith in appeals court. So, well, here we go. An appeals court may uphold Judge Eileen Cannon's decision to dismiss the classified documents case against former President Donald Trump, an attorney said. I love it. An attorney said. Well, guess what? Everything I say is an attorney said too, much to the dismay of everybody. There's no credibility in an attorney saying something. I've said this from the fucking start on YouTube, by the way. Like, just because you have an attorney say it. Well, if you have two attorneys in a room, you have two different opinions at the minimum. In 50, an attorney loses 50% of all cases, right? Like an attorney wins 50% and an attorney loses 50%. Like that's just how they go. So an attorney said doesn't mean fucking anything. Prosecutor Jack Smith is appealing. Let's just leave it there. Prosecutor Jack Smith is appealing. What a handsome devil. Cannon's decision to the 11th Circuit Court of Appeals, which has twice overruled Cannon on decisions in the same case, which doesn't mean anything. Just because they've overruled her twice before doesn't mean anything unless it's the same issue. New York attorney Colleen Kerwick, hold on. Colleen Kerwick. Let's see who the fuck she is. She's an entertainment attorney. No. I specialize in trials, entertainment law, and mediation. I'm special litigation counsel per diem for several New York City law firms. Okay, look. Knowing the hilarious irony of an attorney talking out of school on their practice area, what the fuck does this woman have to do with deep constitutional issues that have never been litigated in the history of the United States? Okay, I want to see. Here's her LinkedIn. Oh, God. I don't want to sign in. Damn it. Fuck off. Hold on. I hate LinkedIn. No, I don't want to agree and join. No, I already have 1 million fucking accounts. All right. I specialize in trials, entertainment law, and mediation, special litigation counsel for several New York City law firms in need of expert litigation services. I also serve as general counsel to a music label and a film company. I do everything for my entertainers, including contracting, intellectual property rights, and dispute resolution. As for results, I tried a fraud case to verdict before Judge Bruno, prevailing for my client, New York Supreme Court. Achieved a settlement in a fraud case before Judge Thompson, prevailing for my client, District of Connecticut. Achieved a decision in a fraud case before Judge Leibovitz, prevailing for my client in the New York Supreme Court, and in a fraud case before Judge Gomez, prevailing for my client, New York Supreme Court. I prevailed in a trial which went to verdict involving fraud. So she's a fraud trial specialist. Okay, great. Education background, who cares? Served as a room mother for my son's elementary school class and as Cub Scout leader in community service. The fuck does that? What does this have to do with anything? Okay. So, all right. That's her LinkedIn credentials. I don't know. Colleen Kerwick. I'm the Disney princess single. That's not her. It's from a Facebook. I don't think that's probably not her. Anyway, here we go. Sorry. It's always interesting. It's like, why are you asking her? Now, look, I know why no one's asking me. I'm like going out there being like, hey, I want to talk to you guys. But someone reached out to her. Newsweek's like, oh, well, we want to hear what New York attorney Colleen Kerwick has to say on the issue. Do they like bother to find out if she has any fucking idea? Again, I'm not a person who says that like licensure standards in commentary are necessary. That would be very stupid of me to do so. But if you're a major media organization, you presumably have resources to vet like who you're talking to. Why are they asking this person? Like you go, okay, well, we want to get an attorney's opinion on this. I know, we'll ask Colleen. All right. Oh, okay. So here we go. She told Newsweek that it's difficult to have a federal decision overturned. Wow. Banger opinion there. Said the appeals court may be persuaded by Canon's argument that Smith's appointment was unconstitutional. Yes. Thank you. Okay, so let's review her analysis so far. Her analysis of why the judge who dismissed the case might prevail against Jack Smith is because it's hard to overturn a judge's decision. So Eileen Cannon may prevail because it's hard to overturn her own decision. And then they may be persuaded by the argument that she used to make the decision in the first place. So I don't know how to analogize this properly, but a federal judge made a decision with the reason of A, and the appeals court has to determine reason A versus reason B, whether they uphold the decision under reason A or overturn the decision under reason B. And her analysis is, well, they might be persuaded by reason A. It's hard to do, and they might be persuaded by reason A. So therefore, the decision may stand. Oh my God, thank you so much for that. That's a fucking banger analysis that we really need. Thank you for the hard hitting. It's not even Colleen Kerwick's fault. Like Newsweek chose to write this. Any attorney out there is going to be like, well, I mean, she might win because she has an argument that she uses as a basis for her decision, and the appeals court may agree with her. Let me put it differently. Eileen Cannon might lose this case because there's an argument against what she said, and the appeals court may agree with the argument against what she said. Well, I don't know. I mean, that might happen. Oh, thank you. Thank you, Nick. Brilliant analysis. D. Huat gifted 5 memberships. Thank you, D. Huat, for that. All right, here we go. Good Lord. She said the issues in the case are novel and may reach the U.S. Supreme Court. Yes, they've never been litigated. Smith will have to show that Judge Cannon abused her discretion or erred as a matter of law. So, this is an interesting analysis. It's smart and dumb at the same time because this is a novel issue. So, is it an abuse of discretion or is it clear error, which is the standard? Well, Colleen doesn't know. I don't either. I'm not shitting on her, but it's a novel issue. So they'll have to decide whether that if she abused her discretion or if she made a clear error as a matter of law. Well, yeah. I mean, that's what they'll have to decide. But there could be more analysis here. Like, which standard should it be? Should it be abuse of discretion or should it be clear error? I don't know. Colleen should answer that. She said the appeals court may accept Cannon's reasoning as there's no statute backing Smith's appointment. Well, there's no law saying he should be appointed, so they may accept her reasoning. Why don't you tell me more, please? Like, give me anything. This is the most. That's a Ricada law analysis right there if I've ever seen one. Judge Cannon reasoned that special counsel Smith's appointment eroded the basic separation of powers principles by wresting from Congress its constitutionally prescribed role in the officer appointing process, Kerwick said. Yes, thank you. Now, this is better. No statute vests the attorney general with authority to appoint a special counsel like Jack Smith. Smith was not nominated by the president, confirmed by the Senate, and Smith was not appointed pursuant to a specific regulation. Correct. There's the important analysis. But here we go. While there may have been special counsels similar to Smith before, this is actually good. This is good on Colleen. I like this. Their legitimacy was assumed versus decided. I've been saying this for a while now. Just because we've done something some way doesn't mean that that's the way it should be done. The government largely operates on agreements, handshake agreements between the branches, where we go, oh, well, I mean, I guess let's do it this way. We don't want to fight it. Let's see. Smith, while there may have been special counsel similar to Smith before, their legitimacy was assumed versus decided. If Smith prevails before the 11th Circuit, whoever reversed Judge Canon in this case before, Trump is likely to take this novel issue up to the Supreme Court. Well, yeah, actually, no. If Smith prevails, if Smith gets back in the case, Trump is likely to take this case there. Yeah, I think so. Again, Trump's probably going to appeal it. Yes. She said that if the 11th Circuit agrees with Canon, it should still allow the Justice Department to bring a new action against Trump via constitutionally appointed special counsel. Well, yes, maybe if it's within the statute of limitations and they actually, want to appoint a new counsel, but everything that's happened so far has to be thrown out. But she's saying double jeopardy shouldn't attach. I'm not so sure, actually. I'm not so sure. At some point, it becomes onerous and burdensome to the defendant. Let's see. Here we go. Newsweek contacted Trump's attorney in Canon's office for comment via email on Monday. In December of 2022, the 11th Circuit sharply criticized Canon. This is where it goes off the rails of the headline for me. While overturning one of her earlier decisions, after she decided to appoint a special master to oversee the classified documents discovered at Mar-a-Lago, which would have greatly slowed Smith's case, the 11th Circuit quickly agreed to hear his appeal. The 11th Circuit unanimously ruled that Canon improperly exercised equitable jurisdiction in hearing the special master motion. Okay. Court said the law is clear. We cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant, nor can we write a rule that allows only former presidents to do so. Great. So that has nothing to fucking do with the current decision. Like, these are deeply different constitutional issues. The issue in this case, or in this ruling, I should say, by Canon, is whether Jack Smith can have the power, can have standing, can have jurisdiction to bring a prosecution against the president of the United States. Special counsels require vesting as an officer of the United States. Like, that's actually the statute, special counsel statute, is that an officer of the United States, U.S. attorney that's been nominated and confirmed, would be appointed special counsel. Now, they haven't always done that, but that they're supposed to have. That's way different than this question of a special master being appointed in the case. Special masters are people who kind of delegate out where various tasks in a case involving either multiple charges or multiple issues, different jurisdictions, things like that, can go. She decided to have a special master, and 11th Circuit's like, you don't fucking need one of those here. You don't have the right to do that. On July 15th, Canon, a Trump appointee, dismissed the case after ruling that Smith had been illegally appointed as special counsel. Well, that fucking matters, by the way. And all of us should want this basic principle upheld. Like, if the attorney bringing charges against you doesn't have the right to do so, they shouldn't be able to do it. Before the dismissal, Trump faced 40 federal charges over his alleged handling of sensitive materials. Look, I've never met those sensitive materials. I did not meet them in a Saks Fifth Avenue changing room. I've never seen those sensitive materials. Not the kind of sensitive materials I like to look at. I don't like to grab them by the sensitive materials. Seized from his Mar-a-Lago estate in Palm Beach, Florida, after he left the White House in January 2021. He was also accused of obstructing efforts by federal authorities to retrieve them, which, again, if he had the right to take them, he should be able to obstruct efforts to retrieve them. But the question is, did he have the right to take them in the first place? Trump pleaded not guilty and has said the case is part of a political witch hunt, which it is. But this statement is true whether he's actually guilty or not. It is definitely part of a political witch hunt. Maybe that bears stating. A political witch hunt can employ valid charges and valid legal questions. That doesn't make it not a political witch hunt just because the questions are valid. It just can still be a political witch hunt. Just because a prosecution is legally valid doesn't mean it's not part of a witch hunt of some sort or another. And obviously, the prosecution of Donald Trump is overtly politically motivated. And people who fall back on the justification, well, it's fine to be politically motivated because he's guilty or whatever. It's like, well, no, it just means that the charges would be valid and the convictions would be valid. But it doesn't mean that the sort of normative or moral or ethical standards of do we prosecute political enemies doesn't mean that that's not being violated. It just means that it's legal. And there are different questions of what's at play here. Legal versus appropriate is a wildly different question, as I think anybody who hates me can agree. What is legal versus what is appropriate are two different things. And we all have different ideas of what's legal or what's appropriate, but we're supposed to have a uniform understanding of what's legal or not. All right, here we go. Niyama Ramani, a former federal prosecutor, well, fuck federal prosecutors, by the way, and the president of West Coast Trial Lawyers, a law firm in California, said he was stunned when Canon threw out the case. Well, he's stunned. He believes that the 11th Circuit will overrule Canon. So listen. No, let's finish up his statement and then I'll do my stupid problem. He quote, "Unfortunately, this seems to be another bad ruling by a bad judge," he said. "And I wouldn't be surprised if her order is overturned by the 11th Circuit, which would be her third reversal in the Trump case." It doesn't matter how many reversals. The question is whether the reversals are valid exercises of judicial appellate power. But let's just Eileen Cannon. Let's just do this favorably towards Trump. Eileen Cannon has issued several orders favorable to Trump. She looks at the special counsel statute and she says an officer of the United States has to be appointed special counsel. And she goes, is Jack Smith an officer of the United States? It's nominated and appointed or nominated by the president and approved by the Senate. And she goes, no, it's not. There's a legal argument that says that this guy doesn't have the right to bring the prosecution at all. I'll dismiss the case because it's a criminal case. And if there's no standing to bring a criminal case, then we probably shouldn't have that. Now, Jack Smith is a private attorney that was appointed special counsel by Merrick fucking Garland, the abject loser that he is. And so Jack Smith goes, oh, well, I have the authority to bring the case because I was appointed special counsel, but he wasn't properly appointed special counsel. So imagine this, a private attorney in Delaware, hypothetically, is you're like local attorney general of your state. Let's say you're in Missouri. No, let's not do that to the Missouri attorney general. Let's say you're in, I don't know, Ohio. Ohio says, I'm going to appoint this random Delaware attorney who's not licensed in Ohio to practice. I'm going to make him a special counsel and he's going to prosecute you instead of just one of our attorneys doing it. And then you go before the judge and you're like, this fucker's not even licensed here. He doesn't have any authority over me. Like, what the hell is this? He's not within the statute. So the judge would throw out the case. Like, that's how it would happen for everybody else. Like, this guy might be an attorney somewhere, but that doesn't mean that he could just be picked to do a prosecution. He has to be vested with the power of the state to do so. And there's a process for doing it. If he doesn't have the power of the state vested in him properly, then the prosecution should be thrown out. You want to bring it up from someone else? Go ahead. Do that. That's fine. But why the hell are we like, I can't, this lawyer who's a former federal prosecutor is stunned that the judge threw it out? All that should tell you is that federal prosecutors are so far up their own fucking asses with the power that they have that they can't imagine a judge throwing out a case brought by a federal prosecutor, because they usually don't. But that's a bad thing, not a good thing. They're so deferential to the idea that they can do whatever they want, that there is no law or rule regulating them, that they can't imagine a federal judge saying, no, you can't do that. But it's pretty fucking clear. Like, I don't know. I've reviewed the argument and take my word with a grain of salt. But it's pretty fucking clear that Jack Smith wasn't legally appointed as special counsel to prosecute Donald Trump. So why should we be surprised at all that this judge throws it out? I'm not sure. Maybe you guys know better. Who knows? Let's see. What do we got here? But anyway, that was that headline. Eileen Cannon has thrown out the case. That's proper. Jack Smith is kvetching about it because, well, he is. And this is how prosecutors work. This is how the government works. I don't know how to explain it otherwise, but they just assume their power, and it's up to you to prove that they don't have it. They should have to do it in the opposite direction, in my opinion. But anyway, let's see. I think I have one more story to discuss. Oh, this one's kind of interesting. There's another SCOTUS topic, but I'm not going to do it today. And it's this idea that's been bandied about now. And that is that, they're going to pack the Supreme Court. They want to pack the Supreme Court. That's the entire concept. They hate the idea that there's a conservative majority and they just can't get around it. So now they're going to pack it. But I don't want to talk about that tonight. I want to talk about this right here. Attorney General Andrew Bailey. He's the Attorney General of Missouri. He says, hey, Kamala Harris and Joe Biden, it is a felony in the state of Missouri to knowingly transport an illegal alien. See you in court. That's funny, right? That's a good one. We're going to talk about why he said that in just a second, but we're going to have one more word from our sponsors. One more here. This is from, let's see, Positive, like Positive, which is healthy pet food snacks for your dogs. Again, there's a QR code on the right side of your screen. It looks like the right side to me. Do you rely on big woke corporations and the corrupt medical establishment to keep you healthy? Well, I hope not. Why would you trust the same globally owned corporations to keep your pet healthy? It's a good question, right? Actually, my dog eats better than like most people. It's fresh food and all that bullshit. It's time we stop relying on them for anything. They hate us. They want to keep us sick and just want our money. I've no lies detective. We at Rumble started Positive Health because pets are an extension of our family, and it matters that they get clean, nutrient-filled, vitamin-rich superfoods to stay healthy and happy. That's why we created a range of superfood supplements, supplement waffles, not blue waffles though, that your pet will love, packed with natural healthy ingredients that promote better digestive support, bone health, vision, and immune strengths. They're also rich in anti-inflammatories, vitamins, and minerals essential for your furry family members. Look, guys, if you care about your pets, Positive is here for you, right? Head over to positive.com right now to check out our superfoods and other products. Use code STUDIO to save 15% on your first subscription order. Guys, this is simple. Do you want good stuff for your pets? If you do, go to positive.com. Check them out. It's a Rumble exclusive, so your pets have free speech along with their good products. But look, I don't know about you guys, but my cats are outdoor cats, but we feed them very well. Same with our dog, which is an indoor dog, but we feed her very well, much to my dismay, because indoor dogs are cancer. In my opinion, you guys can like yours. But if you have this pet it's an investment in, a little member of your family. I know you guys like your dogs. I know you guys like your cats. Check out positive.com. Yes, it's a cute play on words. And use promo code studio. Save 15% on your first order. And, you can help out your little furry friend there. Don't help out furries, though, just your furry friends. All right. Thank you to positive.com. And again, thank you to 5G Free for sponsoring the show today, partnering with this toxic channel. All right, here we go. Let's go back to this. This will be the last story of the night. And then we'll see how we're doing. We might still do a locals exclusive show. I'll let you guys know. So Attorney General Andrew Bailey, again, the Attorney General of Missouri, says it is a felony in the state of Missouri to knowingly transport an illegal alien. See you in court, Kamala Harris and Joe Biden. Now, this is pretty good. Drop Barracuda says furries deserve fresh food too. No. Look, I'm sure there's some good furries out there somewhere. I'm sure. But we all know they deserve an Elon Musk flamethrower. The wrong way. Sorry, I had to get through this monster so I could have some Coke. Yum. All right. Here we go. But okay, so this is in response to Joe Biden, who does anybody think Joe Biden has made any of his own decisions lately? Lately, like in the past 22 years or so. I don't think Joe is piloting the bus anymore. Again, unless it's sometimes like an image sears itself in my head and it's like, it's so horrible. I have to share it with you. Remember the like Acme cartoons, well, like Looney Tunes and shit, when there'd be like a pie. Oh no, Tom and Jerry. This is mostly Tom and Jerry. It'd be like a pie baking in the window, and the like scent would be animated, wafting, and it'd like turn into like women's fingers, and it would like be like, "Ooh, come here, try the pie," and it'd like grab them by the nose, like and drag them in a line by their nose to the pie, and they'd be unable to not eat it. Right, like that. I think that's the only decision making Joe Biden does anymore is like when he passes like an elementary school or whatever, like the scent wafting grabs him. He's like, oh, it reminds me of vanilla ice cream. I don't like chocolate ice cream as much, I think. But the little vanilla ice creams, I love to smell them. I think that's all Joe is doing anymore. But Joe Biden has now come out and said that he wants to propose a constitutional amendment, and that constitutional amendment will actually undo the Supreme Court's ruling on presidential immunity. So they're so ass mad that Trump and all presidents have presidential immunity for official acts, which this is assumed to exist already, and which is why Trump is not the first convicted felon president because he's the first president to commit a felony. Not by a fucking mile. It's just because they didn't prosecute presidents because we didn't think you should prosecute presidents. Now, maybe again, if you impeach them, sure, there is a line that a president could cross and we go, you know what? That's bad. We want to impeach you. We want to prosecute you. We want to strip you of that protection. Yeah, that's assumed. You can always come up with an example. It's like it's like the destiny argument. So, well, what if the president issued an order from the Oval Office that he could rape babies? Like, would that be reasonable? You could just be immune from raping babies in the Oval Office because he's in the Oval Office. So it's an official act. It's like, well, no, only if he signs the back of each baby with a fountain pen. Then it's fine. Like, what the fuck? Of course that would not. And they're like, see, now the president's immune. He could just rape babies all day. It's like, yes, that's what's going to happen. That's your next logical step. You go straight to to that? Like, that's the fucking conclusion? You're like, what? Well, if he's immune, he's just going to do it. No. Shockingly, I think America might have a problem with baby raping in the Oval Office, right? I think that might be a problem. And then they would just impeach him, and then they could just stab him to fucking death like he deserves. That'd be the idea. But when you come up with these ludicrous assertions like that the president would have unlimited, unfettered power with immunity and he'd be able to do anything, it's like, well, if they tried to impeach him, he'd just kill all of Congress. Like, okay, well, maybe he would try, but he would have to have the backing of everybody. And if he did, we're already lost. Well, he'd have the army on his side. Would he? The army's like, you know what? They're trying. Imagine the layers that you have to go through. Like, let's get rid of the horrific example I came up with. And let's just say he wanted to shoot the men of like a male of every family, like on the Lower East Side of Manhattan or whatever that even means, right? Like, he's like, I'm just going to walk down some street and just shoot every person because I'm the president and I can. And then you go to impeach him. He's like, now I'm going to order the army to kill Congress so they can't impeach me. And the army's like, you know what? This is okay. I'm going to go kill Congress because I actually support the walking murder principle that the president exercised. And we're all supposed to just accept, again, we're supposed to accept that this is how America works and that our fellow Americans and citizens are going to just agree with this and then defend the president. It's like, well, he's got immunity. I mean, I guess we'll go kill Congress now. Jesus Christ. Drop Barracuda says, my dog prefers litter box gourmet, freshly squoze. Ew. It's 71st. Alligan News says, drone strike Obama was kind of bad. Yes, I agree. See, that's the thing. I think drone strike Obama was terrible. I do not think that he has the authority to do that. But you know what? America did, because we didn't impeach him. And we could have easily impeached Obama for the drone striking of Anwar al-Awlaki. Actually, you could have impeached Obama for a lot of things, but that was the most obvious and egregious one. But it was popular enough that the few people who were like, that guy sucks, but he was an American citizen and maybe didn't deserve a missile in his ass at a coffee shop in Yemen. Those people are like, are you really defending that guy? It's like, well, no, I'm not actually defending Anwar al-Awlaki, but I'm defending just the concept that maybe the president shouldn't be able to execute an American citizen just because they're in a foreign country. Like that, and that we don't like them. Like, maybe, I mean, that's kind of what the Constitution guarantees. Like, just because a politician doesn't like you doesn't mean they get to kill you. That's kind of a concept that I thought we all agreed on. But it was popular enough that we didn't impeach him. So, did he get away with it? Yeah. Do we get to bitch about it? Of course. Do we get to say that it was not constitutional? Do we get to say that it was outside the president's delegated authority? Sure, we could say all of that, but it's all an argument until we actually impeach. And if they had the political capital, they could have impeached Obama, but they didn't. They didn't do that. That's okay. That's an okay outcome, by the way. Just because we decide not to impeach a president because they do something and some people don't like it, that's okay. Then you just vote. You exercise that political violence of voting, and you try and change the outcome that way. Or you just stand there and yell about it. But eventually there is a line where we go, all right, I'm probably not going to allow the president to just murder like school children. Drop Barracuda says Clinton's smoking stinky boutique cigars was a thing. Yes, it was. Okay. But because of the immunity ruling, Joe Biden is now hilariously, idiotically, the Democrats are like, no, we want a constitution that says that presidents don't have any immunity for their official acts. And so Andrew Bailey's like, all right, I guess we're going to see you in court. So presumably what he's saying is that Kamala Harris, as border czar, and Joe Biden, as her boss, have intentionally transported illegal aliens in the state of Missouri or out of the state of Missouri, into, out of, through, it doesn't matter, that they knowingly did that. And of course they knowingly did that. They have federal programs that do that. He's going to say, all right, well, it's a felony. So he'll bring charges. And the question is that acceptable? Is that an acceptable outcome? Now, look, I'll have the hot take. No. Of course, the state attorney general should not be able to threaten or otherwise prosecute the president of the United States for an official act just because we disagree with it politically. It's not an acceptable outcome, but that's the fucking point that he's making. And the point that he's making is correct because Kamala Harris and Joe Biden are trying to eliminate the obvious solution to these complicated problems. They're trying to create a system in which there is no immunity where there should be. So he says, this will apply to you. I will enforce it. And this is the right way to fight. That's one of the comments in response to this post. I'm not trying to claim the originality of the very generic sentence, but it says this is the way. And this is the way. You have to, I'm not always a fan of saying, well, the other side's doing it, so we should do it. I do think that principle matters at some point. And we go, okay, well, we want a principled approach to things. And that means that even when the other side does stuff, like if you're anti-cancel culture, you can't just start being, well, I'm going to be cancel culture back at them because they do it. I think then you sacrifice a principle, and I think you lose something there. But in this case, this isn't sacrificing a principle. This is saying presidents should have immunity. And they're saying, no, we want to take away immunity. It's like, well, okay, if you don't have immunity, then we'll enforce the law on you. Because this is the thing. Remember, they're not arguing principles here. They're arguing legality. The principle might be that we don't prosecute our political opponents. But Attorney General Andrew Bailey isn't running against Joe Biden, and he isn't running against Kamala Harris at the moment. It's not their political opponent. He's not prosecuting them that way. He's not running on a campaign on prosecuting them. He's just saying, you commit a felony in my state. You don't have immunity? Fuck you. I think it is the way. It's like, look, if you specifically want to take away the defense that every reasonable person should understand and agree that the president deserves a degree of immunity, at least to official acts, with the common understanding that that immunity can be stripped by the exercise of political will through impeachment. It's not that fucking hard. If a president does something unpopular enough, impeach him. Then you want to prosecute him? Good. You stripped him of immunity, prosecute him. But they should have immunity because they should be able to make those decisions. And it's really hard to impeach a president. And it takes a lot of fucking political will and capital to go after someone who's so wildly popular. That's the point. They're supposed to be king for 4 years. Okay. Alligan News says, so do you agree with Barnes's idea of the only way to charge a former or current president is through the impeachment? Do I agree with Barnes's idea? I mean, I've floated the same notion. What I agree with is the idea that the Supreme Court has defined what presidential immunity is. I think that the Constitution lays out the framework that existed where you should have to impeach. I thought immunity should be broader than the Supreme Court, read. And I think that impeachment would precede the prosecution. Yes. I'm not sure if it's Barnes's idea. He and I said similar things on it, but I don't know his exact position, but I assume it's very similar to what I was saying. That's why I don't want to necessarily say I agree with his idea. I generally agree with Barnes on several issues of presidential power and authority. But I think a president should be immune under the Constitution. I think impeachment, then prosecution is the proper method. And I think that's easily supported by the text. The Supreme Court disagrees, however. So right now, I'm going to agree with the Supreme Court's reading of it and say, now you can prosecute a president for, non-official acts. The Supreme Court didn't say, I don't think, that they can't be prosecuted during their term, but it's generally understood that we would wait till they're out of office. So I guess we'll say once a president is out of office, they can be prosecuted for non-official acts or official acts, presumptions that can be overturned. I think we already had this locked down with impeachment, and I think it should have stayed that way. But hey, this is the way Supreme Court rules it. I'm not unhappy with the result. I just would have gone broader. And yes, I know that that would also mean broader immunities for people like Joe Biden or, Bill Clinton, et cetera. Allegan News says the dormant commerce clause is very large, pickles both ways. Yeah, dormant commerce clause is garbage. That's Wickard versus Filburn, and I'm not talking about it tonight. Zoji Apple says, I say we let loose my satanic raccoons loose at a Harris campaign event. Look, I don't know what a satanic raccoon is, but they sound pretty cool. Yeah, I wouldn't recommend doing it, though. Very dangerous. Very dangerous to do. To talk about that and then to do it. All right. All right, guys. Look. I like Attorney General Andrew Bailey's approach here. I think it brings attention to the fact that presidents do things all the time, that violate state law. And if they don't think that presidents should have presidential immunity, at least as far as official acts are concerned, then we should go ahead and maybe call attention to how frequently presidents violate the law, especially state law. And this is where it gets really muddy. This is one of the things I do think that actually presidents should have blanket immunity from state law, because that gives an individual state power over the federal executive branch, which means that the state judiciary now has prosecuting authority or I guess conviction authority over the federal executive. That's federalism and republicanism. That's the whole cross separation of powers issue. That's two separation of powers issues that should not be allowed, in my opinion. Again, if a president is violating state law such that it becomes unpopular or that it becomes unpalatable, then we should go ahead and impeach him. And I think we can agree that a president going through a state and just murdering everyone in violation of that state law probably would be impeachable. Probably. Except in South Carolina. Drop Barracuda. Opinion. Megan Thee Stallion twerking on stage during Kamala's first political rally perfectly demonstrated Kamala's perception of Black America. Oh, yeah. I think Kamala Harris resents being called Black. Yeah, I think so. I think she's like a pigment purist. Riley U.S. Leafson says, sending support for you and the fam during trying times like these. Hey, thanks, man. You look us down 100 times better. Keep up the good work. We're pulling for you, bro. 100. Thank you very much. Guys, with that, we're going to wrap up the show. Check out the sponsors for the show. Thanks for hanging out. I don't have the intro or outro stuff up here because, again, I was trying out Rumble Studio, called my beta test of it, but I think I'll start adding in the assets that I have over on StreamYard. We'll get them over here so I can actually use those, at least like the background, the and the the fucking intro, outro, stuff like that, so that we can have a little more semblance of a smooth show, even though that's just a veneer and a lie, obviously. But we'll get that up and running, and hopefully it'll become a little bit more natural around here. And again, as I said at the beginning, I won't bore you with a long lecture on this. I'm looking to get back to right now, looking to get back to 3 live streams on YouTube and Rumble a week, and then plus locals content. We'll get, once we get there and kind of get things into a routine, we'll see about adding other stuff in. But that's where I want to get to. The good news for me, I mean, I don't know if you guys care or not, but the good news for me is that my schedule has been a little bit unpredictable because we've had significant time with the kids, and the kids are going to be back in the home very soon. So getting the home and us and everything all ready to get our kids back has been kind of the paramount activity around these parts, and making sure that everything goes smoothly there. I know it was never going to happen. It's totally not. And I'm still like, I'm still just making that all up, but no, it's going to happen actually really pretty fucking soon. So I'm really excited for that. And that's kind of eating up my my time in the best way, because that's what I'm thinking about during most of the day. And that means that I'm not putting together shows, and I'm not going to do shows with without like actually having thought through some subjects. So that's what I'm in my spare time, which is not a ton, as much as it seems like there should be a ton. I'm trying to grab subjects and prepare like some thoughts on them before just jumping on a live stream and hitting play. So that's that. But hopefully I'll have kind of a routine worked out really soon here, and then we'll go from there. Thanks for hanging out, guys. Thanks for sticking around and making fun of me or watching or whatever you do, or just furiously petting your leg. I don't know how you watch YouTube. Don't you question me. But thanks for doing that, and we'll see you very, very soon. Locals in the chat. I'm going to see about doing a local stream in just a little bit. I'll update you there. Stay tuned. Ricadalaw.locals.com. Peace. Peace.